Hi, everyone. Welcome to another episode of Talking Deals with David. Today, we're going to be talking about the new proposed FTC rule. And I've been calling this a special edition only because this just came out, I think, January 5th it was released. So as you all know, who's been following my postings, I've been talking about it a bit on LinkedIn, particularly as it implicates M&A deals. But I wanted to just get out with the LinkedIn Live because I've had so many questions about what's going on with the new rule. What are some of the implications, not just in the M&A space, but just generally with non-competes. And so I thought this would be a great opportunity to answer questions, talk live about it. And I'm really excited because I've got two of my partners in the labor and employment group at K&L Gates to talk with me about it. And we're hopefully going to have a good conversation. And also, as I always say, feel free to ask questions. You can type those in. We'll wait till some people start to join. Having done a few of these, I've learned that, people tend to come in 3 or 4 minutes, 5 minutes after we start. But let me just, Brian is actually coming on. So anyway, I'm joined by Kathleen Parker, who's a partner of mine in Boston. Hi, Kathleen.
Hey, David.
Hi. And Brian Spang, who's also a partner in the labor employment group at K&L Gates in Chicago. Hi, Brian.
Good morning, David. Hello.
Hi. Now, we were going live, and when I tell people we're actually going live, we're going live. And so we had some issues with Brian's connection, but he's here and sounds good, looks good. So I think we should be in good shape. So here's what I want to do, because there's so much to cover. What I think we'll do first is sort of get a lay of the land from Kathleen as to what are we seeing just generally with non-competes around the country right now, assuming that we don't have an FTC rule in effect. And that will give us kind of a baseline to see, what is the current situation? Where are some risks and opportunities that you have as you're thinking about non-competes? And then Brian is going to help give us a high-level overview for those who haven't delved into the 200 plus page FTC release, which we've been sort of parsing through. Give us a little bit of a high level overview of what the rule says, any key, exceptions, definitions, at least get a sense of where the FTC is positioning this to start. And then I think we'll really get into the discussion, particularly how it may implicate mergers and acquisitions deals, but also just thinking a little bit around corners and thinking into the future. Where might this go? What should you be thinking about as you're looking at your non-compete agreements, either in the M&A context or outside of it? So I will get started again. If you have questions, we can see those. We'll take a look at those as we're going. So please feel free to ask additional questions and type those in. So Kathleen, maybe just give us a little feel from your perspective of where non-competes sit generally outside of the FTC rule, and what you're seeing with clients of ours in terms of how they're approaching non-competes.
Sure. Yeah. So everyone always sees these big announcements, these big rules that get discussed and think, oh my gosh, something is changing in the non-compete space. And while this is a important development and something that clients are definitely going to need to address, one thing to keep in mind is that states have been regulating non-competes, and there's been increasing hostility towards non-competes in various states and in various industries for years. And so, especially where with the pandemic, workforces became much more mobile. People were hiring employees in all sorts of different states that they were never in before. Right now, what we're working under is, what do the states say about non-competes? And as many people think of when they think of California, there's those extremes where there's already 3 states that essentially ban non-competes unless it's in connection with the sale of a business. And that's California, North Dakota, and Oklahoma. So if you have employees in those states, there's already extreme hostility towards non-competes that you need to address if you're entering into agreements with employees in those states. And under most laws that regulate non-competes at the state level, there are prohibitions against kind of choosing a different governing law to avoid that state's restrictions. So you can't just say, oh, well, I'm a Delaware-based company or organized under the laws of Delaware. I'm located in New York, so it doesn't matter what California law says. That's not true. You can't just easily kind of avoid the state's law if you have an employee there, if they are hostile to non-competes. Now, even those have exceptions for the non-competes in connection with the sale of a business, because the law does see those differently, which we'll of course talk about today, given that we're focused on M&A related issues. But it's just something to think about. You would need to know where your employees are, or if you're an employee, where you are, and what that means for the enforceability of non-compete. So taking a step down from those kind of extreme one end of the spectrum that are basically completely banning non-competes except in the sale of a business, you've got other states that are heavily restricting non-competes. And those include, Massachusetts, Illinois, Washington State, Washington, D.C., even Georgia, states that you might not necessarily think of. A lot of states do that in the form of banning it for low wage workers. So you can't have non-competes. And in some states, you can't have non-solicitations of customers when you have low wage workers, which, should kind of make sense. What is the reasoning for really restricting the movement of people at who are non-exempt or who are, earning hourly rate or who are earning, below $30,000 a year or something like that? What is the real business reason for having a non-compete? And so you've got that next level down where they're significantly restricted in terms of who can be subject to non-competes. But then even once you get into that world of, okay, we can subject this person to non-competes, states are imposing an incredible amount of some kind of more form requirements. You have to have certain language, you have to give certain notice periods. But others are saying, well, you have to give separate consideration. Historically, people would say, well, your new employment is sufficient consideration. And that is the case in some states, even that are restricting the use of non-competes. But others are saying, no, you kind of need something else. And you particularly need to be careful if you're having existing employees enter into non-competes, because those employees have a different kind of bargaining power at that point. You're not going to quit your job necessarily if you're suddenly subject to a non-compete. So the states want to protect employees in those situations. So many states, Massachusetts included, are imposing requirements where you have to provide some sort of separate consideration for non-competes entered into during employment. Massachusetts, Connecticut, DC, Illinois, those states that are kind of increasingly or have historically been hostile to non-competes. And then you also have a lot of states that have pending legislation. So it's kind of this moving target that you could do an analysis. You could roll out non-competes and non-solicits for your employees and then kind of pull those forms off the shelf the following year. And you might have to redo them. You might have to update them depending on where you have employees. So what I've been seeing a lot of clients doing, what I've been counseling a lot of our clients on, is take a step back when you're thinking about a non-compete. Obviously, you want to be compliant with the law. So step one is you have to know where your employees are. Did people move during the pandemic? Did you suddenly go into a different state? What does the law look like? What pending legislation is out there that you need to be aware of, so that if you have a agreement that someone signs, in 2023, if you hire another employee in that state, do you need to kind of revisit that state and see, well, now is that compliant with the law because there was actually pending legislation? But then once you're kind of check the box of you're compliant with the law, you have to think, okay, what am I really doing here? What am I trying to protect? Because non-competes are coming under stricter scrutiny, even in states that don't necessarily have laws that ban or restrict them. There still are court cases that are going to really impact the enforceability of a non-compete and even of a customer non-solicitation, which some states see as a form of non-compete. And for example, those are banned in California too. So you want to look at your restrictions. So what I've been advising clients and what clients have been very receptive to is come up with multiple tiers. Group your employees into certain categories and really think, well, is this type of employee someone that I could justify having sign a non-compete, and that if required under the law, I need to pay separate consideration for, because that can get expensive as well. And then kind of think about what is the business reason, because even if you're in a state that doesn't statutorily ban or significantly restrict non-competes, the kind of baseline is, well, what's the business reason for subjecting someone to this restriction? And can you achieve that business reason, that objective, without the extreme of a non-compete or a non-solicitation of customers or even a non-solicitation of employees? Can you rely on the trade secret protections that are statutory in most states, or your confidentiality agreements? So it's really kind of taking a more refined kind of scalpel approach to restrictions on your employees now than just the pull it off the shelf, everybody signs the non-compete, and we go on our way.
Yeah, I mean, it's interesting, Kathleen. I mean, it sounds to me, it reminds me in the M&A context, you have data privacy, all kinds of different state regulated or even foreign country regulated areas, and you just get a patchwork of of laws, and the compliance burden of doing that, it becomes excessive, especially in a fast changing area, like you're describing, where not only do you have to monitor the legislation and what's happening, in state legislatures around the country, but you've got common law cases that are coming out, from time to time, and so that is an additional overlay. But I love that suggestion of sort of being very tailored. I think gone are the days. I mean, I maybe overstated for effect, but I was saying that the writing is on the wall, meaning that people are fixated on the FTC rule, and I think for good reason. It's a very aggressive, move into that area that traditionally, as you described, was vested in the states. But you're seeing, state after state, even if they're not banning outright, they're moving toward this more restrictive approach. So I think, if you're going to be proactive about it and not, reactive, the approach you described makes a lot of sense. I take it, Kathleen, that some of the strategies that I have used, and others, certainly in the M&A area, of trying to have exclusive jurisdiction provisions, exclusive forum, other kinds of things, so that if people moved into a less favorable jurisdiction, you would somehow have a hook. I'm not sure those strategies really ever worked, but I'm guessing that those kinds of approaches to deal with people that may be relocating probably don't work now even more.
Yeah, and that's where you really have to look at the individual state laws, because while many of them have these kind of prohibitions on choosing another law, there are different, more refined things that the laws do say about that. For example, if someone moves after employment, let's say you're in a favorable jurisdiction that doesn't really regulate non-competes very much, they enter into a non-compete, and then after termination, they move to Massachusetts. A Massachusetts court would not say that that prior non-compete is unenforceable, because the law in Massachusetts says you have to have been employed at the time of your termination, or living there, for a certain period of time. So different laws have kind of different restrictions on that, but it's certainly no longer the case that you can just rely on kind of your typical choice of law analysis of, well, this jurisdiction, we have a legitimate reason for choosing Delaware because we're organized under the laws of Delaware, and all these things justify that. That is not going to fly in many states for sure.
And typically you will put the law governing where the employee resides. Is that right? At least as an initial, they may relocate, they may have other things. And I assume you can also, have requirements that they indicate where they're moving to or where they're working, so that you have some kind of ability to track that. But yeah, so you don't love the idea of trying to, put a different state's law, let's say, if somebody is living in one of these areas that has restrictions on it. I assume that's not going to work, because it's where they're performing the services and residing where you're most likely going to apply that law. Is that fair?
Yeah, and kind of the safest choice of law in any employment arrangement, in terms of enforceability, is where the employee is. So, that's kind of always the easy default. And then you kind of go to where is the company. But where you're dealing with a jurisdiction that does have these statutory requirements that, for example, California says, you can't, and Massachusetts as well, you can't avoid the jurisdiction that the employee is in, whether they're in California or Massachusetts, by just saying, well, but I'm a New Jersey company. That doesn't work. It's where the employee is, which, makes sense from a common sense perspective. You're going to be restricting that employee in that jurisdiction, primarily. So it does make a lot of sense to kind of just default to that. And then you can kind of see where, well, I have a whole host of employees in these jurisdictions that are not hostile to non-competes or do not already have statutes. So can I come up with a form agreement that complies with all of those laws and chooses the law of, where the company is, assuming the company itself is not in Massachusetts or California or one of these hostile jurisdictions, so that's another option. So it's kind of a lot of different buckets to put people in. And once you put them in those buckets, it's, we have the employees that are in these other jurisdictions, and maybe we can have one agreement for them. And I just saw one comment come across. So also true in the M&A context. So the M&A context is separate, that's something that we'll talk about a little bit. But in general, these state laws that have prohibitions on non-competes or significant restrictions on non-competes kind of accept out non-competes connected to the M&A in the M&A context. But you do have to look at those individual laws to see, well, who actually qualifies for that exception. It's what percentage of business ownership do you have to take it out of the employment context and into the M&A context. And what you also have to think about is, well, if I have someone who is a business owner but then is becoming a employee, and I subject them to a non-compete connection to their employment, well, you can't kind of tack on to the M&A exception. The M&A exception is, exclusive to that deal. And then if there's a separate employment agreement, all of a sudden the employment law would come into focus and be relevant.
Yeah, we'll talk about that. It's a great point. So, okay, my takeaway before flipping it to Brian is, I think in today's world, whether or not the FTC rule comes into effect, I think the way Kathleen describes it makes a lot of sense. Be very tailored in terms of who really needs to have these non-competes. Think about all of your IP protection. So trade secret protection, other kinds of agreements like NDAs and non-solicitation agreements. All of those can probably be very effective in most of the cases. And so you can narrow the group. Don't just, do sort of form agreements for everybody who signs up and bury a non-compete. And then think about the same things you've always done, which is the scope of the non-compete, how long, make sure that it complies with the state laws, as Kathleen mentioned. So all of that is important, but it still sounds like a bit of a mess because you've got all of these different, jurisdictions that have different approaches. And then on top of that, people can, move much more freely and relocate. So one of the benefits I think I see, at least from the FTC's approach, is they're just attempting, whether it's successful or not, to kind of preempt the field and, just replace all of this patchwork with a federal ban. And so, Brian, why don't you take us through sort of a high level of what the FTC is proposing and how that, proposed ban would work?
Sure. The rule itself is actually fairly narrow and simple. You had mentioned the notice of proposed rulemaking is over 200 pages. The proposed rule itself is only 5 of those pages, double spaced. The rest of it's background trying to get there. So at a high level, non-compete clauses are defined as a clause between an employer and a worker that prevents the worker from seeking or accepting employment after they leave. It's that simple. Well, that wasn't the details, but basically, which is your standard non-competes, like you think of the very broad ones that I've seen in a lot of M&A deals where I've reviewed, where you can't work in any capacity whatsoever for any competitor in this space. This is a traditional non-compete. Worker is defined broadly. It's not just employees. Importantly, it would be defined to include independent contractors. So any individuals working for an employee, whether they're officially an employee or an independent contractor or a sole proprietor, would be covered. And basically, the rule says that non-compete clauses under that definition are unfair methods of competition, and therefore the FTC is claiming the authority to prohibit them under Section 5 of the FTC Act. And one point that's come up that our group's been discussing, and there was an early question, is the scope of the FTC Act. If you're a nonprofit, the FTC Act defines corporation, it governs corporations, and corporation is defined to not include nonprofits. And in the M&A space, or where non-competes are used, that first goes potentially to healthcare systems that are nonprofit 501c3. So under the strict definition of corporation and the FTC Act, nonprofit healthcare systems would not fall under this ban. Now, on that point, the FTC's view of what is nonprofit changes over the years, and whether business is being carried on for profit is something to keep an eye on, to see if this administration in particular, and this FTC would start to expand their idea of what for-profit is. So just a note on that. The ban, as you mentioned, David, expressly preempts all state laws, and also would apply retroactively. So not most state laws, when they're that Kathleen was talking about, when they're implemented, are only prospective and looking forward from the point of the effective date of the law. This proposed rule says that all non-competes, whenever they were ever signed and entered into, are prohibited and banned for all of history. There's a requirement that the employer has to notify both current workers and past workers for whom they have reasonable access to contact information. So it would actually require the employer to go back and send a notice to all former employees they can find, as well as current employees, to let them know your non-compete is no longer in effect. And then there's a point on that I wanted to make. I was looking through, which I thought was interesting, because part of the rulemaking has to estimate cost. And I thought this group would be interested in the fact that they estimated, the rule estimates the cost of composing a message in digital format to inform a company's current workers of this ban. And they estimate it would take one single employee 20 minutes, one HR employee 20 minutes to write an email that would inform all current employees of the ban. And they estimate that that would cost $9.98 per company for 20 minutes of an HR employee's time to send a notice about the ban. I just throw that out there.
Well, I like how they're, they can break it down to $9.98. I have a feeling it would be much more time consuming and expensive to draft that and figure out where it goes and everything like that. But it's very interesting. So you're saying, Brian, that this is retroactive and leaving out sort of constitutional or other things that might come into play. But so this would mean, if we just take it very simply, if this FTC ban passes the way it is, that not only would all future non-competes, at least by covered employment situations, be banned, but an employer would then have to rescind, even if they paid consideration for non-competes, right? They would not necessarily be able to claw that back if they don't have any provisions and agreements to provide for that.
That's right. I think that's a point that is not taken into account for money that has been paid under a bonus plan or under a garden leave provision or anything like that, where money has already been paid, is promised to be paid for a non-compete. Those practical aspects are not addressed. I can think of arguments to be made, whether it's specifically in whether clawbacks are in an agreement or not. If now the agreement isn't enforceable and everything that agreement is based on is no longer valid, I can see company arguments to go back and say, well, there's no more contract, it's void, so I want my money back anyway, regardless of whether there's a contractual term. So there's a lot of those practical considerations, I think, that are not addressed in the rule or the comments. And then the next question, I think, becomes, okay, so that's non-competes. Well, what about, and we touched on it a little bit, what about non-solicits, customer non-solicits? What about non-disclosure agreements? Are those governed by the rule? Or is the rule just limited to non-compete, traditional non-compete clauses? And the answer is maybe. The rule sets up a functional test. And it says if a contractual provision is a de facto non-compete, operates as a non-compete, in fact, operates to prevent someone from leaving and joining another company, in fact, no matter what it's called, the rule would consider that as prohibited too, as a prohibited non-compete. And there's two examples the rule provides. One is a non-disclosure agreement that could be written so broadly, basically saying everything you ever learned about this company you can't disclose. Arguably that would prevent someone from working in the industry, whatever the industry may be. And there's another example about training costs and repayment. If the repayment provision is so onerous, it would prevent the person from leaving to work, that would be banned. I think about customer non-solicits. Now, the rule doesn't address customer non-solicits. They're referenced in the commentary. But if you think of an industry and a salesperson in particular, whatever industry it is, it has a book of business and makes all their money on commissions and has a set number of customers and wants to go to a competitor and doesn't want to start all over again and wants to call on the same customers, there's a pretty good argument to be made that even a reasonable, narrow customer non-solicit that would be enforceable in pretty much every state that allows those kind of restrictions would be under this functional test, a de facto non-compete. The employee could say, well, I'd have to start over. I won't make any money for the next couple of years. I can't take employment elsewhere within the industry, or else I'd lose all my customer base. And the FTC could agree in that case and say, yes, you're right. So that's banned and prohibited. So that's something that I've thought a little bit about as we look into this. What's a de facto rule? And there aren't any standards for what to govern what's de facto, what's a functional non-compete. Right, as it's set up, it would be whatever the FTC decides it would be, which obviously is not an optimal, doesn't really present a bright line rule that the FTC wants to provide.
So the idea that, you're seeing people say, oh, non-solicits are okay. It sounds like, again, it's going to be a facts and circumstances type test. You're not going to be able to, go too extreme on some of the NDA or non-solicit provisions and, functionally create a non-compete. So it may be that in certain industries or certain types of work, you have to be much more narrow than you do in others. Kathleen, I guess now we'll talk about the exception for the M&A in a second, Brian. But so what do you think about that? So in terms of what you do on a day-to-day basis, I know you do lots of things. This is just one, but on the non-compete side of things, to me, there'll be obviously a lot of thinking around some of the nuances, the definitional items, whether people are, going a little bit too extreme on the non-solicit. But it sounds to me like this would at least solve, whether it's solved in the right way is a different, matter, but it at least solves that issue you described of having, to root around in 50 different, jurisdictions and follow the case law. So, I mean, are you seeing that at least as a way of simplifying for companies that operate, either globally or, throughout the US? This sounds like at least a pretty bright line rule, and that makes compliance a bit easier, I would imagine.
Yeah, definitely. And I think that's part of what's driving companies now to take that more refined approach and really, so we don't have to root around in 50 states' laws. Maybe they take their C-suite and say, okay, well, these people are going to be subject to a non-compete. They're in 2 states or they're in 1 state. Let's look at that. And jumping off the non-solicit, the California bans customer non-solicits, so does Oklahoma and North Dakota. California also has case law, lower court case law that's hostile towards employee non-solicits. And one way that I've been drafting customer non-solicits is tying it to the employee's connection with the customer rather than the company's connection to the customer. And those, even in states that allow customer non-solicits, are likely going to be a lot more enforceable and are likely going to be more in line with what a company would actually seek to enforce if it were to come to a dispute. So, instead of saying this employee is prohibited from contacting any customers or prospective customers of the company during that, the company had during their employment, it's who did the employee actually interact with, develop relationships with, obtain confidential information about. And those are the restrictions. So there are other ways to kind of narrow and make non-solicits make more sense, even in those jurisdictions that allow them. And so that's kind of another more refined approach that I've been recommending and that I've seen clients be amenable to, because it's just more realistic with what they're going to ultimately want to protect in the future and what they might negotiate for in the future if there is a dispute, or what they might seek to enforce in the future, instead of having these kind of blanket non-solicits. And even some states say you can't prohibit people from soliciting prospective customers, whatever that means. They have to be actual customers. There's no protectable interest for a future customer that you were laying the groundwork for when that employee was there. So that might be another way that the rule gets kind of refined as well. Maybe they start refining what a non-solicitation of customer actually means when it would be more like a non-compete, and they can clarify that a bit. Because the comment period is really important. Brian mentioned there's the FTC itself put in estimated costs. That's something that it has to do under the rules to justify this law, and what the rule is. And what the comment period allows is for people to say, well, here's a hypothetical. Here's how much it would cost me. I'm a very small employer who's had X amount of people leave over the years. It would cost me Y amount to go inform everyone. That's an effective comment. There's different ways to push back on these rules when they're in their comment period. And under the operating rules, the governing rules of these agencies, they have to take the comments into account. They have to look at the comments. So it's not just a throwaway thing, this comment period, it's very real. And so if you are interested in this rule, you should put together a comment. You should put together a compelling hypothetical. You should talk about the burden that might be on a company. Or if you're an employee that's pro this rule, you should talk about, how it has impacted you. It's a very good opportunity to, especially when you're dealing with a rule that's this kind of broad and unclear, where we know there's going to have to be some refining and clarification for it to move forward into any form. The comment period, I think, is going to be very interesting, and I would assume it's going to be a lot of comments. I think right now it's set at 60 days. That can always get pushed if the FTC is seeing more comments coming in. If people are saying, "Oh, I didn't have time to comment, please extend," I would think that this one's going to get pushed. So use that comment period, whether you're for or against this rule, or whether you have suggestions as to how to improve it, one way or another. That's a real thing that is part of the rulemaking process.
Well, that's why I was thinking that it's so important to, think beyond just the FTC rule, because we don't know where that's going to come out. It may substantially change from where it is now. I doubt it's going to stay where it is. I mean, even the FTC, Brian, you and I were talking about that. Even in the FTC release, they're almost inviting change. They're proposing, they're suggesting areas that they could more narrow the rule and limit the rule. And so my guess is that, they're going to be, attempting to probably just put a very positional kind of flat ban, and then maybe work back from that depending on how the comments come. Is that your sense of, where it may go?
Yeah, that's exactly right. They actually not only invite they specifically invite comments, but they present a couple specific examples of alternatives, which this is the first rule I've ever seen, proposed rule, where the agency makes a rule, but then says, oh, by the way, we also want you to consider this. The two main ones are whether there should, rather than a blanket rule, there should be a rebuttable presumption that all non-competes are invalid unless the employer in certain situations can prove, the FTC would have it by clear and convincing evidence, that a non-compete makes sense in a particular situation. Another proposed alternative is along the lines of state laws that Kathleen touched on, which is whether there should be somehow categorize workers. And this is really focused on lower wage workers, whether there should be a wage threshold, compensation threshold, whether it should be exempt, non-exempt under the FLSA, some way to categorize, okay, in this situation, they're banned. Above that level, you get into C-suite, you get into research and development, you get into real trade secret information, there might be a different rule. The comments mention that then you start to slice and dice. You can slice and dice these in multiple ways too, and then it potentially becomes complicated. But those are two of the specific alternatives the notice identifies and invites comments. And a point about comments, I looked last night. There are already over 2,000 comments made. I didn't look at all of them. Sorry, David, to get ready, but I did notice most, at least what I saw in just skimming, most of them are from individuals and most of them are against non-competes. Yeah. And a lot of them are anonymous. It's interesting. So I don't know if there's work underway by organizations to get people to write in, but there's some of them are just one sentence, like, this is great, I hate non-competes. Some, like you mentioned, David, give a personal story of their own experience, but it doesn't look like the business community has, as of yet, started filing. So I just thought that was interesting. We're already up over 2,000 as of yesterday.
Yeah, it's not surprising to me. I think it's got a lot of people, thinking about this. Well, in the M&A area, we know that there is an exception, because I think the FTC recognizes that, when you're doing a deal and you're paying substantial consideration, just take for the typical case, you don't want the sellers who you've just sold the business, the goodwill, the customers, the entire operating, company that you're now, going to be running, to simply take the money that you've just paid them and set up a competing operation. So the FTC certainly seems to recognize that is an area that you don't want to have a complete ban on non-competes, and that's consistent with, even Kathleen, you mentioned California, and I think Oklahoma and some others that also take the ban approach. They also allow non-competes in a business transaction where you're buying the goodwill, buying the assets of the business. And the FTC rule, I've written about this, as sort of a kind of a blunt approach. It just says, look, if you're a 25% or more owner, partner, shareholder of a business, then as part of that sale, you can be restricted to a sale of business non-compete. That makes some sense. Of course, it's a little bit, it's not very specific, in the sense that you could have a $1 billion transaction where somebody only owns 1 or 2 or 3%, but it's multiple times that person's annual salary. At least on the face of the rule, you would not be able to, restrict that person to a non-compete. So one of the things I had suggested in a post was, maybe you could take some lessons from the parachute payment provisions that, sort of have like a 3x annual, comp type trigger. And you could say it doesn't matter what percentage of the business you own. If you are receiving consideration that's greater than X of your annual compensation, then you could be bound up. So that's an area, whether they move down that road or not. But I do think that this idea in the M&A context means you've really got to start focusing on this in your diligence and in your valuation. Is it a business? If the target is a business that's very much dependent upon these sorts of non-compete protections, very, very much, let's say, tech-based or IP-based, you need to look at that in the context with the patent protection, trade secret protection, everything else, because you may find that you're not going to be able to get as broad and as wide of non-compete protection, under the new FTC rule as you might otherwise have received. But Brian, what do you think about that exception? And do you see some avenues in the planning stage that might give people in the M&A context a bit of relief?
Right. Well, the immediate reaction is what you just described, which is 25% doesn't make a lot of sense in a lot of contexts, in the very small deals and the very large deals. And I was looking up last night as to where that 25% came from, because I thought the listeners would appreciate knowing that. And it turns out, technical legal term, it's kind of a Goldilocks number. And because literally the comments read, the FTC believes the 25% threshold strikes the appropriate balance between a threshold that may be too high and a threshold that may be too low. And that's how I took out some of the parentheticals, but literally they just decided, well, 25% sounds about right. So I think a lot of the commentary will and should from the M&A world focus on that and why that doesn't match up and doesn't make any sense, isn't supported by anything. One way to challenge a rule, in addition to all the constitutional arguments that will be lobbed against this, is just the traditional abuse. It kind of goes beyond their discretion. They just had no basis to make a regulation. And here they're essentially admitting there's no numbers at issue. They just thought 25% sounded kind of right for that. So I think that will be the subject of a lot of commentary as well.
Yeah, I think so. I actually think, and I'm sure you both read that, for people who want to actually sort of get a feel of where this may go, I think I don't know if the technical term is dissenting opinion, but the dissenting view of the commissioner that voted no, I forget if it was 2-1, 3-1, but one of the commissioners who voted no to this FTC ban, I thought, has a pretty well put together, counter argument that addresses, a variety of points that the rule, makes up. And I assume that people that are looking at this and who may challenge in litigation if the rule, comes into effect, we'll be making a lot of those arguments. But, again, from the M&A lawyer's perspective, I mean, to me, it's super important to be planning ahead. You're never going to know, until it happens. And that could be, 6 months, a year. It could be multiple years if it's in litigation. And there may be an ability to get injunctive relief so that it may not ever take effect. But I just think that from the M&A side, and Kathleen, that goes to a lot of what you were saying. I think being thoughtful as a seller, for example, positioning the business in a way that you can demonstrate value to a buyer without necessarily having to enforce, non-competes makes a lot of sense, because you may well find that if you don't do that, you're going to find buyers who are using this as a justification to support additional escrows of consideration, contingent payments that perhaps trigger on certain events versus all upfront payments. They may want to change the structure of the deal. We were talking, offline last night over the email. I think if you look at some of the definitions, it may well be that in asset purchase transactions, so a particular structure that's sometimes used in M&A deals, you may be able to get much broader non-compete protection, even with people that own less than 25%, because of the way the rule and the definitions work. So you may find, and that's typically less advantageous for sellers than it might be for buyers. So you may find, again, that if you don't think about this in advance and start planning your IP protection strategy, in a world where you may not have non-competes, or they might be dramatically limited, I think you open up the door to depressed valuations, or these other kinds of contingent consideration or escrows or other ways that I'm thinking about that a buyer might want to use if it's concerned about paying substantial amounts of money and having key people who may own less than 25% of the business go out and start, working for a competitor or setting up a competing operation. That would be very bad. That would be a very bad result for a buyer. And I think it will trickle through to sellers because it will impact the valuation and the structuring and approach that people take on deals. But Kathleen, what do you think about sort of that discussion? And in terms of maybe your advice that you would have for people that are doing acquisitions, where maybe you'd be asked to, diligence non-compete agreements that are in place, or, maybe working for a seller, thinking about how they might want to package their business, with the rule kind of hanging out there, but also all the other points that you were, talking about in your description.
Sure. I mean, it's looking at, if you're going to inherit any non-competes, obviously you always want to look at what as the buyer, what do those look like? Do we need to enter into new ones? Are those even enforceable? And now, could we be considered entering into the non-competes kind of midstream and not at the start of employment, so that we're subject to kind of additional requirements? I mean, another additional consideration is, and this kind of goes to the point of taking a more mindful approach to the notion of non-competes, just taking a step back. I just want to be clear that what we're talking about is non-competes entered into kind of during employment or at the start of employment. So not only are kind of M&A business acquisition non-competes kind of accepted out, but post-termination non-competes are also a completely different animal. So those are another thing that can be used to protect your assets as well, and protect your values. So in connection with the deal that you're doing as the buyer, think about, okay, we've got these high level employees that we're entering into agreements with. When we structure those agreements, maybe we build in a severance type of negotiation that will protect us, because there will be a non-compete associated with the severance. And that kind of goes to the whole notion of, if you want a non-compete, maybe you have to pay for it, whether it's paying up front or paying at the end. And of course, you leave yourself open to the potential that, well, someone could say, I don't want the severance, I'm just going to go work for a competitor. And that's a risk you take. But that's kind of another thing that you should be thinking of in the M&A context, as well, as you, especially obviously as the buyer, as you embark on this new with this new entity, with this new endeavor. What do I want to negotiate up front? So I know, okay, even if the FTC, this rule passes, even if they're in a state that bans non-competes, well, I have this potential to have a non-compete that's connected to a separation agreement as well. But I think it's also just thinking about, how much am I valuing these non-competes if there's a potential that it's going to be invalidated, and that thing that I bought is worth nothing in terms of the restrictions that can be placed on employees, and just coming up with other ways, whether it's a acquisition, a business ownership related non-compete that can be, 3 to 5 years instead of a year post separation. And then tacking on that for those particularly high ranking individuals or high earning individuals. Well, let's think about our appetite to offer some sort of severance that can have a non-compete connected to it.
Can I segue off of that?
Yeah, Brian, sure.
Looking at some of the comments that were coming in, and what Kathleen was just mentioning about paying for it, basically, and paying money. And offline, this group talked a little bit about paying for non-compete. And I see among the comments, Tanya and Jeremy were commenting about the situation of a smaller business, where on the one hand, the head executive of a small business is in a good position to leave and recreate that business and potentially harm it. On the other hand, small business owners can be under, or executives can be under, onerous and unfair non-competes at the same time, and tie them up from their ability to go. So it's just a paradigm example of what we're talking about. Paying for it. One other option, and I was trying to think about this as the rules currently written, is garden leave, which is a little bit misunderstood sometimes. But for those of you who don't know, it's a concept where instead of paying someone to sit, well, you're paying them to sit out, but they're still currently employed. The idea is it's a generally shorter period than a non-compete. Essentially it's a notice period. The executive would give notice and say, I'm going to leave. And then for the next 3 months or 6 months, they would remain employed. They may or may not be assigned any work, but they would remain employed. So they still have fiduciary duties, they'd have a duty not to go and compete, but they'd get full pay, or at least something pretty close to their full pay. Interesting how that compares to the rule, because the rule is based on ability to find work after you leave. Whether the FTC would view a garden leave provision as problematic or not is an open question. But under the text of the proposed rule, garden leave would be effective. It's effectively a non-compete, but the person is still employed tending their garden for a couple months, usually, which is a concept that has not been litigated a lot in the United States. It's more common in Europe.
Yeah, it's a European kind of thing. But one thing Tanya also asked is, I don't think, some of these statutes or administrative rulemaking, they do sort of carve out exceptions for, smaller businesses, people that have less than 50 employees or 25 employees. So you have these different, thresholds. I don't recall seeing such a thing there. Is that the case, or would it? I think it would apply to all businesses that are, again, for profit. There might be nonprofits or others that are not covered, by at least the face of the rule. What do you think about that question that Tanya had?
Yeah, you're right. No, you're correct. It's a very good question, but unfortunately, no. The rule is it's a blanket, bright line rule. It does not distinguish between the size of a company. Again, it gets to their alternatives, where they're inviting comment about different categories of employees. That can also be the subject of comments, is the different categories of employers. A huge well-established tech company in Silicon Valley is in a much different situation than a 100-employee manufacturing company in Ohio. I mean, it's a whole different ballgame.
Yeah, well, maybe, one of the things, Kathleen, I was thinking about is, in 10 or 15 years ago, there used to be a lot of emphasis on thinking about non-competes in different ways. So you would, in a deal, you might actually separately value the non-compete portion. And there were different, tax treatments. Generally, sellers didn't love that because it typically resulted in ordinary income tax rates versus, capital gains tax rates. And buyers sometimes, depending on the deal, either didn't mind that or were kind of neutral to it. And sometimes you would see that embodied in consulting agreements or some other, arrangement that was, akin to an employment situation, but they were treating them as independent contractors. And that made sense. They weren't necessarily working full time, but they would be available. To me, I think those are a bit more risky because now you actually are entering into some kind of an agreement related to working, which again sort of picks up this definition of worker and employer, and the rule is pretty broad to pick up independent contractors and I would imagine consultants and others. But I think in those situations, I tend to like the idea of making sure that the business related non-compete is sort of baked into the principal business acquisition agreements, as opposed to being separated in a separate agreement, unless of course they really are employed on a full-time basis. But what about that as maybe an additional thing to think about if you have sort of these mixed business and employment or consulting kind of relationships that might be at play?
Yeah, well, independent contractor law is another fun area that's a patchwork of state law as well. So the minute you start talking independent contractors, that's another fun can of worms that you're going to open. Though there is a pending federal independent contractor rule, under various laws. So, but that's pending, so that's another area that's risky. I mean, as Brian pointed out, the independent contractors would be covered by this rule. They're also going to be covered by most of the state rules that I'm aware of. And so it is an interesting option to kind of think about, well, how can I otherwise engage these people? But I do think that, to your point of tying the restriction to that deal document, is kind of your safest bet in terms of trying to get a restriction. And maybe it's defining who's subject to that as however the state law might define it, and then with a little caveat of or as otherwise might be defined under federal law or state law as amended, giving you that wiggle room and tying the restriction. And those restrictions can be much broader. You know, non-competes related to employment typically are 1 year, 2 years are reasonable. Some states say no more than one. Others say 2 is presumptively reasonable. Typically, business sale related agreements are 3 to 5 years, and some can be even longer under state law. Obviously, you can run into the issue of, well, someone stays for 6 years and then leaves, and you're out of luck with enforcing that. But then you kind of can think about, well, but did I get what I paid for as the buyer? Did I get what I paid for? And now, you know, they can go compete or solicit, or relying on the non-solicitations that you could enter into with them as well. So kind of refining the scope. I will say, if you do have a deal where you have a restrictive covenant agreement, let's say, and then you also have people entering into an employment agreement, one thing that I strive to do is make those consistent, at least in their scope. I've looked at a lot of agreements where there's a restrictive covenant agreement that says one thing, there's a employment related non-compete that says another thing, and it's kind of makes your head spin and thinking about what this person would even know about what they can and can't do, and what the company would even be able to keep track of and try to enforce. So one little kind of very simple tip, if you're in a deal, is just look at those agreements and try to make them as consistent as possible, because it just creates a really weird patchwork of obligations if you don't.
Yeah, it's a super good point, and generally a good point with drafting, agreements, particularly in an M&A context where you have a lot of different things working in different ways, making sure that there's sort of an overall theme and consistency. So, Brian, I guess one final quick question, and then we'll wrap it up. Jeremy asked a thing, I think, which would be kind of right up your alley, talking about, just the practical problems with enforcing non-competes even now. So just under the current situation, because you've got all the different state laws and obviously you have burdens of proof and other things that you have to do. So he talks about, the difficulty of doing that. I assume you agree with him that these can be challenging and costly if you're going to enforce these. And it's probably becoming more so, given the more sensitivity around these. But maybe you could, for a minute, comment on Jeremy's.
Yeah, that's exactly right. It is very challenging litigation. It's a area where what is written on the page may or may not be enforced. In an M&A deal, and then the deal goes bad and there's a lawsuit, was there a breach? Did someone do they weren't supposed to? You look at the four corners of the document and you figure out whether it happened or not. Here, I know Illinois does, but most states have a Supreme Court precedent that says the same exact restriction can be enforceable in some circumstances and not enforceable in others. And it's really about equity. It's about fairness. You're up, especially when you're trying to get emergency injunctive relief. You're in front of a single judge who, depending on what side of the bed they got up that morning, feels a certain way. It feels a certain way about non-competes. You don't know that. So, and a lot of the times in the litigation context, it comes down to, was there some bad act? I tell people all the time, if someone solicited clients on the way out the door, if someone slipped the resignation letter under the door Friday, I guess we don't do that anymore, we email it, and shows up across the street Monday with all the clients, if there was downloading activity, you're more likely to get it enforced. If someone just wants to go and work in a job and it's not necessary, they didn't do anything wrong necessarily, and it's an overbroad agreement, it's going to be really tough. I think interesting, the commentary to the rule, to propose rule, talks a lot more about the just kind of prophylactic effect that these have, the effect on people trying to make their decision whether to go or not. It doesn't talk about litigation as much. I think the focus of the FTC, in fairness, is what people think and what they do or don't do because of the threat of litigation, the in terrorem effect, as courts like to call it, of an overbroad agreement, as opposed to the actual litigation. But yeah, the actual litigation is challenging. When you actually file and actually go in, it's challenging to enforce unless you've got some really, as I say, good facts for the lawsuit, bad facts for the former employer, because something bad happened to your intellectual property or to your client base.
Yeah, well, definitely, it definitely talks about that, and we've all seen that where it's an imbalance of power in many cases, and also future employers are also quite concerned. So whether or not the non-compete is, would ultimately be enforceable in most cases is never ultimately tested. And, you can have a former employer sending letters to the new one saying there's this non-compete, now about it. If you hire that person or continue to employ them, then you're also going to be, sort of an aider and abetter, potentially tortiously interfering. You got all of these different things. And a lot of employers may say, I'd rather just hire somebody who doesn't have that non-compete. And I think the FTC sort of gets to that, gets to that idea. Kathleen, so what's the last, I'll give you a minute or something, and just your last kind of perception of what people should think about now that we've talked about the rule, where you see things sitting now and where things may, be headed.
Yeah, I mean, people should just think about, how do you justify the restriction? Because you're going to have to justify it. And to this point that Jeremy last raised of injunction, what would you argue in an injunction? Also, are you the type of company that's going to try to enforce this? There are companies, I've encountered them, I've represented them, I've been on both sides, that are just, they by matter of policy, they will file an injunction. They will do it. There are others that don't want to do that. So think about what type of, if you're an employer, what type of employer are you? What type of company are you? Do you have the appetite to do this? How can you beef up other restrictions? I think something that came up in our call yesterday that I thought was a great idea, David, that you had was, typically you see in your restrictive covenant agreements that if there's a non-compete. So if someone goes somewhere else, they have to inform the employer, your prior employer. That's part of your exit obligations. You have to return the materials. Maybe you even have a certificate you have to fill out that says, I don't have any confidential information. I didn't download any, I didn't take any. And also here's my computer and my laptop, my badge, all that stuff. Within that, impose an obligation regardless of the restrictions that they have on them, even if it's just a confidentiality agreement, that they have to tell you where they're going. And if they don't, that's a breach of that agreement. Now, what's the teeth? You have to think about what's the teeth associated with that. But if they don't comply with you, but that's something to think about, because I've definitely seen employees leave. They don't update their LinkedIn profile for a number of months. And then suddenly, they're at a competitor. And we just heard that one of our customers is leaving for them. So that notion of knowledge of where they're going and kind of engaging in a dialogue maybe with their new employer to find out exactly what they are doing so that you can get peace of mind. Maybe sometimes even what I've had companies do is you sign kind of a supplemental agreement with the employer that says, yep, they're going to be screened off from this. They're only going to be doing this. We'll inform you if that changes in any way. So just kind of thinking about how you can get that information that you need to know whether there is a risk to your intellectual property or goodwill and customers.
Yeah, it's great, and thanks for reminding me of that. Yeah, well, there's so much to talk about. We could just go on and on and on. And I do think that, if people are interested, if we have developments in that area, we could easily do, a part 2, because I think there's a lot. And actually, Kathleen, maybe we should talk about doing one on that independent contractor, because I see that a lot as a major issue in M&A deals. And that's even maybe worse in terms of all the different approaches that states and federal government takes to determining that. So that's something we could talk about. I also, a final thing, an anonymous LinkedIn user, I'm not sure who that is, talks about upgrades to information security and how this may impact that. I completely agree with that. I think it's an excellent point, and I think we touched on that. Again, I would pretend the rule is in effect. It doesn't, to my mind, that's a better way of thinking about it. And if you're a seller or a buyer, look at the business that you're either selling or buying as if there are no non-compete protections in place, just to get a sense of how are they approaching IP and information security generally. There's a lot that can be done in terms of the commenter notes, restricting access, using AI and tech and other ways to protect your information beyond just having sort of these non-competes. I think in a way people just got comfortable with these non-competes, and it provides a good stick. But I think people are going to have to look at other approaches, incentivizing workers better, finding ways to keep people happy, wanting to stay longer. Kathleen and Brian came up with good ideas on thinking about other ways to use severance agreements or other approaches. And then some of the things we talked about in the M&A area. So I think that we will stop for now. But again, if you have questions, if you need help looking at some of those things, Kathleen and Brian, obviously, we're certainly available to do that. And thank Shelby. Thank you for running this production and everything. And I appreciate everybody listening in. I do have another one coming up, I think, next week on the 24th, talking about synergies, M&A integration, and best practices to capture value in M&A deals. So I hope for those interested in that, please join in. So thanks very much. Send us any questions or comments, and appreciate you joining us today. Thanks, everyone. Thanks, Brian. Thanks, Kathleen.
Thanks a lot.
Okay, bye.